Come in from the waiting room and we'll get started. Okay. It's like it slowed down a bit. Uh, Good morning. I'll just start out with a few of our regular housekeeping instructions. Make sure to keep yourself on mute while we're talking, but if you have a question, feel free to raise it in the chat or unmute yourself. Well, I think we have a short amount of questions today, so we may have time at the end to answer some. So if you didn't get any in before our cutoff this week, feel free to stick them in the chat and we'll try to get to them at the end of this. Reminder that all of our commentary today is just general legal information. It is not legal advice. Please make sure you understand that. And if we come across a question that sounds too specific or is asking for too much information, we'll let you know because we're trying to just be a sort of a broad and general informative hour. As we always remind you, make sure that the information that's in the chat is also just questions, requests for clarifications, and that there's not a legal conversation going on in there, because see previous comment about this just being a general session. Ken and I were just talking, we've been getting a lot of questions about the CTA. As you'll see, I think the first 4 questions today are related to it. As we have mentioned in the past, CAI lost an initial court ruling, so our advice has been to comply with the deadline of December 31st for a January 1st start date. We just got an alert this morning that there was an order issued yesterday in Texas for a what was stated as a nationwide preliminary injunction. We haven't had a chance to really delve too far into that, so you may want to discuss with your legal counsel or further review before you rely on that. The short answer to that is, or the short upshot of that is that there might be a short reprieve in the deadline for filing, but I think there's more information to be looked at there. There's bills right now in both houses of Congress trying to get community associations exempt from the CTA. So we don't know what's going to happen, but right now it looks like there may be a slight pause in the requirement to comply.
So let me make a couple
go ahead, Ken.
comments on that.
Yeah, please.
The information we got came from National CAI. It is National CAI's belief that the court injunction in Eastern Texas does apply to all community associations incorporated within the United States. And the order is not that you don't have to report. The order is that the CTA cannot pursue enforcement efforts against corporations that have failed to report. So the case clearly is an opposite outcome for the same lawsuit that was brought by National CAI in a different district court. So these two judges have disagreed, and one is, the CAI court refused to issue an injunction, and now the Eastern Texas one has issued an injunction, and because they're in Texas, they've decided that it should apply nationwide. So we don't know how soon the disparity is going to get resolved, because normally what happens when you have 2 district courts with clearly opposite results is it's going to get bumped up to some higher level court and a decision will be made. Neither of these actually resolves whether the Corporate Transparency Act is legal, because these are just preliminary injunctions. So the Texas one would say that if you don't comply, you can't be penalized. It doesn't actually say you don't have to comply, but I guess if there's no penalty, you can, the risk is certainly reduced if owners fail to comply. And if you have board members who are threatening to resign, you can say, well, this court case gives you at least some kind of reprieve. But I guess I would also remind people that the information being asked is really minimal. The only new information that you are giving the Treasury Department is a copy of your driver's license. And it's not like the government doesn't already have your driver's license. It's just a different branch of the government. So anyway, sorry to interrupt, Lisa.
Nope, please. Okay, so again, we'll talk a little bit more about the CTA in the questions, but finish up the preliminary stuff. A reminder that if you have not started the process for getting your budget ratified, you're almost too late to get it done for January. So make sure you're thinking about that and getting those done so that you can, if there is going to be an increase in assessments, that you have timed that properly. Yeah, again, you may not be able to do it for January 1st if you haven't sent those out yet, but talk to your attorney if you have questions about that. We had provided information on if you wanted to get the lax Monday morning minute. I don't know if Chelsea, if you can put that link in the chat again. And then a final comment about our new fee schedule. We have our office has sent out a new fee schedule for 2025 to our clients. It has been about 3 years since we've updated our fees, so we're it's hopefully it doesn't appear as too much of a shock, but it has been some time. So we're have sent that out. Just a comment on that if you ordered flat fee work in 2024, even if we don't deliver it to you until 2025, we will honor the 2024 rate for that. So if you're working on a restatement or an amendment or something like that with us now, that rate will still be honored. A reminder, we won't be doing Q&As on Christmas, which is December 25th, or New Year's, which is January 1st. Those both fall on Wednesday this year, so we will not be holding Q&As on those days. Anything I missed there, Ken? Are we ready to get into?
I think we're good to go.
Okay. As promised, the first question, where do things stand with the legislature and the condo board status with reporting and a lot of information that board members may be reluctant to give to the state? So Ken gave a pretty good summary of what's going on. We're assuming this question relates to the CTA and not something else because the CTA is on everyone's mind. Their reporting requirements, as Ken mentioned, still are in effect as of January 1st, 2025, unless something changes, unless we hear something more, we'll let you know if we do. We have been and are still advising people to comply. And if you have questions about how to do that or what this is or what the heck I'm talking about, we've been talking about this quite a bit in our Q&As the past 2 months. So feel free to check out our YouTube channel. I think if you just search CTA or Corporate Transparency Act, you would find that information pretty readily. And as Ken said, the only information you're required to provide to the government is your driver's license. And so no privileged information, no private information, that stuff's already out there. It's going to be sent to the government. You're just required to get a FinCEN number, provide that to whomever's reporting, and that is it. Anything else to add on that one, Ken, or go right into the next question?
Well, the next one's related, so I'll just go ahead. We understand that volunteer board members are required to file with FinCEN unless they opt out by October 4th. We're not informed about the opt-out option until December. So I'll offer that we don't know of any opt-out option. So we don't know why someone thinks there's an opt-out option. One thing that is important to remember is that giving your information to the Treasury Department as a person to get a FinCEN number is what means you don't have to give any private information to the association, and the association doesn't have to keep or provide any of that private information. So the association just has to give the FinCEN number. So, and I guess with today's information, the risk of non-compliance has been substantially reduced. And that's really one of the things that is hard for anyone to evaluate right now, is that the Corporate Transparency Act has these, big threatening fines and threats of jail terms to try and get people to comply. But I think that the likelihood that the government is actually going to impose those kinds of fines and any jail time on a board member for a nonprofit corporation is incredibly small. That doesn't mean that there's not the potential for it, and no one really knows how the government might try and enforce it. And it might be different under a Trump administration than it would have been under the Biden administration. So, we just don't really know. Our position has sort of been, it's just not that big a deal. It is not that intrusive to provide a copy of your state issued driver's license to the Treasury Department to get a FinCEN number, because if the Treasury Department wanted it, they just get it from the state anyway. So again, no opt out. So it's your turn again, Lisa.
Thanks. I was also going to say that I think I can say this, that our law firm is also a corporation and also has to comply. So it's not just community associations, it's anyone who's incorporated. So it's not I don't think it's not being met with the same level of reluctance in other communities. The next question, the same topic. Our community has a board member that will be stepping down because he does not want to provide his personal information for the BOI reporting. We'll be filing online by December 31st. But isn't this for all those who are on the board in 2024, or is it only for those on the board at the time of the initial filing being done? We want to know if the board member is still liable for not providing the information for the 2024 filing. So the short answer to this question is you file or you report the board members as of the time you are filing. So if you file on December 15th and that board member is a member on December 15th, then you provide their information in your reporting. Anytime a board member changes after you've done your initial reporting, you have 30 days according to the requirement to update that reporting. So if you have a change in the board, someone resigns, someone's elected, you have 30 days from the date of that occurring before you have to update your reporting. This is, the same requirement that's there for the Secretary of State, that the Washington Secretary of State that you do annually. Usually, if you have a change in board membership, you're also supposed to update that within, I believe, 30 days as well. So it's not this isn't a new change. I think we've discussed in the past that, or a new thing, that it might not be a terrible idea to have as a standing agenda item on your board meetings, just to jog your memory if something has, or jog your action if something has changed. If you're meeting monthly, then you would probably be able to catch if something like that happened quickly. I don't know what prospective or what kind of enforcement action or who's actually monitoring this or how quickly that will happen. So I don't know if you do it on the 31st day, what that means or what that's going to happen. But that is the way the requirement is written, is as of the date you file the report everyone who's on the board. And then if there is a change, file that change report within 30 days. Anything to add to that, Ken?
No. And the next question is, what's the current status on the financial reporting? And I think we've covered that. So we'll let you get to number 5.
Okay. Change of topic. When associations are required to operate under WUCIOA, will they need to amend their documents in order to meet the statute with a 51% majority, or will it require the percentage already mandated in their current documents? I will start out by saying I'm not sure where the 51% comes in. I'll talk about that later, but the short answer to this question is no. Once WUCIOA takes effect, the statute trumps any inconsistencies in your existing documents. So you do not have to amend anything if you don't want to. You should potentially consider talking to your legal counsel. At this time would be a good time to figure out what in your document conflicts with what will be in place in 2028 when WUCIOA takes effect. I think that is helpful to know. It's helpful for the board. It's helpful for owners to know what changes may be coming. You could adopt WUCIOA now for a lower percentage than what is required in your documents. If your documents have a high percentage, that would be a 67% of the votes cast supporting the amendment. But you only have to have 30% of the community involved in that process. So put differently, if 30% of the community votes on the amendment and 67% of those voting support it, you'd have the amendment would pass to change your governing statute to WUCIOA. or to adopt WUCIOA. It doesn't change other things in your declaration if you're actually restating information. So it's basically a simple amendment that says, hey, we adopt WUCIOA. As I mentioned, I'm not sure where the 51% came in. I was saying to Ken, maybe the person's thinking about the budget ratification process where 51% needs to reject the budget. It may be that your documents have 51% requirement, but that is not one of the statutory requirements for an amendment. Trying to think if I missed anything. Anything to add to that, Ken? Did I miss something?
No, we've got a very similar topic is going to come up,
Okay,
which I guess is the next one for me.
that's right.
So I'll just go into that. The question is, I'd like to know how to prepare our condo association for the full rollout on January 1 of 2028 for WUCIOA. Our association was formed in 1974. Our governing documents date from that era and an early 2000s revision. What steps should we take now to get started on this? So the short answer is it really depends. And it will depend on what conflicts there are between the statute and your documents. And of course, to know that, you've got to go through and look at them or have an attorney or someone compare your current document to the requirements of the statute. And so you may or may not want to amend your documents to have them reflect what's in WUCIOA. If there are true conflicts in the document, then the board alone can amend the declaration or CC&Rs following a process that's in WUCIOA to remove the conflicts. It's got to be an actual conflict, not something which is voluntary or permitted under WUCIOA. So if you have a requirement in your CC&Rs for 51% to amend the CC&Rs, but WUCIOA requires 67%, that is a conflict. You can just leave the document the way it is and get 67% every time you make an amendment. Or the board can follow the process and revise the document without a vote of the owners to change 51% to 67%. The process for a conflict is to propose the change and give it to all your owners so they can comment on it and wait 30 days. And then the board is allowed with a 2/3 majority vote to approve the declaration amendment, and you can record it. You then have to send a copy out to the owners and say, even though we sent this to you already as a proposal, now it's been done. So there are some things which are permitted under the declaration, or excuse me, under WUCIOA that may not be permitted under your current statutes, but you have to adopt those as amendments. So for example, if you want to make individual owners pay the insurance deductible, or you want a rental cap, those are permitted under WUCIOA, but they do require an actual vote by your membership because those are not conflicts with your current documents. One of the things which we would suggest if you're looking, well, what's the first thing we should do? It is have somebody who understands WUCIOA go through your CC&Rs and tag what the conflicts are. Percentage ownership might be a conflict. Whether you're required to have open meetings or not will be a conflict for many condominium documents. The voting requirements that are in WUCIOA may be a change. There's a lot of conflicts between your current documents and the statutes you're under now because the HOA Act and the Condo Act have both been amended, I don't know, 6 or 8 times in the last 5 years. And no one's gone and revised their governing documents to reflect those changes in record keeping and the rights of owners to review records, voting, holding meetings via Zoom. And all those are still, the statutes still apply. and they apply without it being reflected in the governing document. So we do think it's valuable to look at the documents, tag those things that are a conflict, and then make a decision about whether or not you want to amend the documents to reflect those changes. Anything you want to add, Lisa?
Well, just I think touch on what you just said, which is that we don't know what the version of WUCIOA will be. Assume there will be a few changes in the next couple of years too. So consider that as well when you're considering what to do. Okay, next question. In a brand new HOA where each unit has different square footage and shape, who decides how to apportion the HOA dues? The builder's lawyer? Does the state have a formula? How can these be changed? The short answer to your question is that the declaration or the CC&Rs state how dues or assessments are apportioned. So the person that is making those decisions is the declarant. That is when the declaration is recorded, that sets out the boundaries and percentage ownerships and things like that of each unit in the community. If we're talking about a new community, I'm assuming that we're talking about WUCIOA, and that is the governing statute for a new community. You can look to certain portions of that which talk about how to create or what the allocated interests are. 64, 90, 235 discusses the allocated interests, discusses the creation of those interests. And each time a new community is created, the declarant will record a declaration that apportions, as I said, those interests. If an association wants to amend their declaration to change the percentages, they should look at RCW 6490-285, subsection 4, which says that an amendment may not, I'm paraphrasing, change the boundaries of any unit or change the allocated interests of a unit without the consent of all owners to which at least 90% of the votes in the association are allocated. And then it also has to be the owner whose unit is affected by that change also needs to vote to approve that. The statute doesn't restrict or limit the ability of the association to allocate costs. So that's different from the interest allocations. But the current documents could limit the ability to allocate the costs differently. You, in that case, would use the 67% that we discussed earlier about amending or restating a declaration and making a change to the cost allocations in your declaration. I'm not sure if that answered, if I missed something there, Ken, or if I answered the question, but I think the ultimate answer to your question is the declarant decides. And if you want to make a change, there's some pretty large hoops to go through if you're talking about changing the allocated interests in the association.
Yeah, so originally under the first condominium statute, the percentages of ownership interest, cost allocation, and voting all were the same. They were required to be equal, and they were based on the original estimated value, dollar value of each unit. So that it didn't matter what the size and shape was of your unit square footage. It only mattered what the dollar value was assigned in the original declaration. In 1990, the Condominium Act said, well, you can have a different allocation of ownership interest, allocation of expenses, and voting power for each of the units. And it's whatever the declarant decides. And WUCIOA has carried that over. So WUCIOA allows for a different percentage ownership interest, a different allocation of costs, and different voting. So it's frequent to have condos with different percentages and sizes, but they still have equal voting power. I don't know why the statute is specific to state that you cannot change the allocated interest without the 90% approval. It does not say the same thing about revising voting power or cost allocation. So next question. Is a homeowner allowed a hearing before each and every fine is assessed for a covenant violation? even if the homeowner has had previous hearings with the board for the same violation that are ongoing and the homeowner was deemed non-compliant in the last hearing. For reference, this is a 6438 association. So our answer would be the same whether you're a condo, a HOA, or under WUCIOA. And the question is really too fact specific for us to give legal advice, because it's really going to depend on the circumstances, the kind of violation we're talking about, maybe the amount of money you're fining, and the time between violations, etc. So, and we've even got, I'll say, some differences of opinion in our own office, where I think the collection side of our office wants you to say yes, because they have the greatest possibility of collecting by having had an opportunity to be heard every time before every fine. It's one less thing that the owner could challenge. On the other hand, my side of the office might say, look, if it's the same problem every week, I don't think you need to issue a new violation notice and a new opportunity to be heard every week if the problem is they're not mowing their lawn. I think you can have one hearing, decide they're not mowing their lawn, assess a fine weekly until they mow the lawn, and I think that would probably be okay. But part of the thing I would want to make sure people remember is that the only purpose of the fine is to get compliance with your governing documents. You're not looking at it as a revenue stream. And so it should be one of multiple ways you're trying to work with your owner to try and get compliance. And, even if we took the more conservative approach and said you need an opportunity to be heard every time, that doesn't mean you actually have an actual hearing. The owner has to ask for the hearing. And if an owner did ask for a hearing, I would suggest that you hold the hearing. And yeah, so anything you want to add on that, Lisa?
No, I get, yes, I guess. From the collection standpoint, this is often the place where we find we are unable to collect on a fine or a compliance violation because this offer of due process is not made or is not made correctly. So if you have compliance letters with the due process language, great. If you have questions about those, talk to your counsel so that you're not in a position of having to waive or not charge those fines because you did not provide the proper notice to the owner prior to trying to charge the fine. That's just a sort of a side comment because I see those a lot.
Well, yeah,
Okay.
another side comment. We've had clients where they will come back in 2024 and say that they sent a notice in 2022 and the owner's still doing it. And that's a case where I'd say, well, absolutely, you need to send a new notice and give another opportunity because you waited a year and a half.
That's right.
So,
That's right.
yeah.
Okay, next question. Is it illegal to compensate board members? If not, what is your advice for communities who are considering this option? The short answer is no, it's not illegal to compensate your board members, but many governing documents specifically prohibit compensating board members for their service as a board member. So I would start there. Look at your governing documents. What do they say? If they say no payment to board members for their service as board members, then that may be the end of the answer to your question. We have discussed this topic in prior Q&As. We generally don't recommend that board members are paid for their service as directors. It kind of creates a whole host of other things. They potentially become an employee of the community. You may have other requirements such as L&I insurance, unemployment insurance, having to issue W-2s, having to create certain workplace environments. So a big caution on discussing compensation board members for their service. That is not to say that if a board member is doing something else for the community, they are your project manager, they are doing the accounting. It is possible that for that service, not their action, or not their role as a board member, but as their role as the accountant or whatever that may be, they may be compensated for that service separately. So again, if you have questions on this, talk to your legal counsel or potentially your CPA as well if you're looking at paying people. If you're insisting on doing that, if board members, you're having a hard time getting board members and you want to pay them and it is not strictly prohibited in your documents, make sure you go through a very open budget process. Well, required to go through an open budget process anyway, but make sure that this is very clearly laid out in your budget and that it in your ratified budget. It's not buried as some line item. It's called out conspicuously that this is a payment. This line item is the compensation to board members. And that way that your owners, once the budget is ratified, are less likely to have a strong means of challenging the payments to the board members later. Again, I think this is, technical questions about how to make payments and how to issue things. Talk to your CPA if this is a route you go down to. But generally speaking, it's not illegal unless your governing documents specifically prohibit payment as their service as a board member. But again, there may be other jobs they do that may be compensated. Anything you want to add, Ken?
Well, something I just thought of is that the other thing this creates is an obligation for the board member to actually perform their duties. And, I've certainly, I would be concerned that you start paying board members I don't know, monthly fee of something, $50 or whatever. And what if they don't show up for board meetings, or what if they don't prepare for the board meetings? How do you decide whether or not they are essentially earning the money you were trying to compensate them for? But, our recommendation is avoid it if you can. And then I would suggest you talk with an attorney to make sure if you're going to start doing it, you've done it in a way which is going to survive a challenge by owners. Next question. The contractor we want to hire wants a 50% down payment up front before they will start the work. Should we pay that? So our short answer is almost always going to be no. That we do not like providing money in advance of actually getting services. The protection you have under the state's laws where there's a bond posted by a contractor and you can go after the bond, that bond is very limited in its dollar amount, and it is to settle all claims against a particular contractor. So I think that the dollar amount was just raised. It had been $12,000 for a general contractor. And we are routinely seeing contractors ask for 50% of $200,000 and $400,000 contracts to be paid in advance. And we had in 2024 a fairly, I'll say, respected large contractor just disappear, leaving multiple of our clients with unfinished work or unstarted work where they had paid between, I think, $20,000 and $40,000 each to the contractor. Contractor, I think, filed bankruptcy. Did they file bankruptcy, Lisa?
They didn't, and I think they're actually performing work again. But another one did file bankruptcy, so there are a couple.
Yeah, and basically the sad advice we had to give the clients is that it will cost you more to try and pursue recovery of the money than you are likely to recover from the contractor or the former contractor, because they can just walk away. And we had it also happen where a roofing contractor had basically just closed his doors, and the person who was running it just opened up a brand new roofing company. And the question is, well, how do we go after the former contractor for the bad work, which we discovered 2 years after the fact? And the answer is you probably have no recourse. So we are, as a lawyer, strongly opposed to giving money in advance. We do recognize there are some exceptions or some occasions where the only way you're going to get work done is to provide money in advance. And so you need to evaluate the risk of doing that against the expediency of trying to get the contractor work. Elevator contractors are one where we know you cannot get your elevator replaced without giving advance money to the manufacturer for the elevator equipment. And it's, there's just not a way around it. If you need a new elevator, you're going to pay money in advance to get them to manufacture it. The risk of the elevator contractor going away and not perform the work is lower than a guy who's working out of his pickup truck doing painting or roofing work. And there may be some things where, it's a $20,000 contract. Your risk is $10,000. You're a large community. You need it done right away. And you can just decide, we'll take the risk. And we understand that that may be a reasonable decision for a board, even if we're advising you not to pay for work in advance. And we do recommend you find an alternate way of being fair to both the contractor and the association if you need to get work done. So if you're talking about a $400,000 project and you decide you need to make, payments every 2 weeks to the contractor so he can make payroll for his employees, that's okay. You can write a contract and we can help you do it that would allow the contractor to submit invoices so that as work is performed, you are paying for the work and they can pay their employees. But giving a contractor $200,000 up front when no work has been performed, we do not consider to be reasonable, really in most cases. Anything you want to add, Lisa?
It may be a red flag also if a contractor is unable to begin work without such a large deposit, because that means they're not adequately funded to order supplies, et cetera. So that's something to consider, I suppose, when you're looking at those. Okay, next question. I think this is our last question. So if you have others, go ahead, Chelsea.
We have a couple follow-up questions on that. Do you want to take them now or wait?
Sure, go ahead.
All right, the first one is contractor leaving the job. Didn't state law change to not allow filing bankruptcy as a means to eliminate liability?
I am unaware of any change that would have made a difference. Bankruptcy law is federal law, so nothing in the state could really affect it. And bankruptcy courts overrule state courts all the time in how they think things should be done. So if someone has a piece of legislation that they want to refer to us, I'm happy to look at it, but I'm aware of nothing. Lisa?
I was just gonna add that there's always exceptions for things like malicious or intentionally bad acts, but that doesn't sound like what we're talking about here. But that's a very specific case by case analysis. So that's, if you have something like that, definitely bring it to your attorney.
And also, if a contractor was given a deposit and stopped work, what can we do?
The answer is you can sue the contractor. And so that's part of why we frequently end up advising clients that there's no point in spending more money and losing it to try and recover money already lost. It starts to depend a lot on the dollar value of the loss. And it often is one of those things where it's wrong, it is offensive, it is, it's just not right. And there's a principle that you want to pursue. And the answer really ends up being, well, how much do you want to spend to pursue your principle? Because it isn't right. And you're absolutely, correct that what the contractor's doing is unfair, wrong, illegal. The problem is that you don't have any mechanism of trying to recover except the courts, because even the statutes which allow you to go after a contractor require that you file a lawsuit in superior court. And so you just need to decide is, what's it worth? Is it worth it monetarily? Is it worth it for the amount of effort you're going to have involved? And I'll offer litigation is not a fun process, even if you're in the right, and even if you've got all the attorneys working efficiently for you, it still can become a miserable experience, and you can have counterclaims filed against you, and it's one of those things where I wish there was a better process, but we don't have one. Anything else to add, Lisa?
No, just that, we feel just as badly. We've had some terrible Zoom calls with boards when this has happened, and it doesn't feel right, but as Ken said, sometimes that just may be the cost benefit analysis you make. But there may be options, so definitely talk to your attorneys if you're confronted with this situation. All right. Last question that we had prepared in advance is, what is CLG's advice on recording meetings, either by voice or AI? We always understood that recording was not a good option, as it could open the association to potential liability from contentious owners. The short answer that I have is, again, kind of it depends. Generally speaking, it's not I personally don't think it's a great idea to record meetings by whatever means you're choosing to do it, because it does become a record of the association. If you're keeping those meetings, then you have to have records retention policies. You have to have a system for managing those things, decide how long those recordings are available. But there's a big caveat to that. If it is the secretary keeping the recording as a personal record for them to make sure that their minutes captured the actions of the board, and then the secretary deletes the recording, and then the minutes are published to the owners, that may be a reasonable thing for the secretary to do. If you have an outside party or some kind of a discussion about something that is important to the community, something that is happening in the community that you want all community members to have access to, that also may make sense to record that meeting and make it available to the owners. That, if you're doing a restatement or an amendment to your declaration, or as Ken mentioned, you have your insurance agent coming or something like that, that may be a reasonable reason to have a recording made available of a meeting to owners. So I think the question is sort of, what are you doing with that recording, and why are you doing it? And where are you going to put it? I think is the other thing. How long are you going to keep it? So I think it as kept as a record, just because you think you should keep records of those things because you want to use them to get back at someone later or something like that, that's not a great result or not a great reason to do it. But there could be good reasons to have recordings of meetings. Generally speaking, we would say, the meeting minutes, the actual minutes that the secretary does that are then approved by the board and then sent out to the owners, that is the record of the action taken at the board meeting, not a recording. So if you're using it for that purpose, I would say that doesn't make super great sense. The actual minutes themselves should be the encapsulated reference for the action of things that happened in the meeting. It should not be a transcription, just motion passed, motion did not pass, etc. Anything to add to that, Ken?
No, I think that you covered it. So,
Chelsea, any questions in the chat that we haven't covered?
Quite a few. All right.
Okay.
So first, would you provide general information about collecting attorney fees associated with lien and foreclosure actions and the process?
Boy, that's a big question. I can just say, generally speaking, if attorney fees are incurred in the collection of assessments from a delinquent owner, generally speaking, those are recoverable as part of that recovery process. So whether it goes to litigation or not, your attorney, generally speaking, should be including those fees on your ledger, on the owner's ledger for recovery. I'm not sure how much more to say about that. They are specifically authorized both in the statute and typically in your declaration that attorney fees that result from the collection of outstanding debts to an association are collectible against the owner. Anything to add to that, Ken? I'm not sure how much more I want to go into that, but that is what I do.
No, I think that's your area of expertise, so I'll let you
Okay.
answer that.
Okay.
All right, regarding rental properties, can an association have a residency requirement before an owner may use their property as a rental? Example, owner must have resided for at least 1 year.
So the governing documents can have that kind of a requirement. It's not something the board can adopt by rule. It's not something that can be done with a bylaws amendment. And it also is something which, depending on the kind of community, may require 100% approval by the owners. I would have to see the individual community's documents to be able to answer that question. I will offer, though, that the FHA, not the Fair Housing Act, but the Federal Housing Authority, which provides guarantees for FHA mortgages, does not like what they call a seasoning clause. And the seasoning is you have to have an owner occupy or own the unit for a year or two before they can rent. I don't know why. This is a change that FHA did 2023, and they started refusing to get FHA guarantees if there was a seasoning clause in a declaration. So we've had some clients who've removed those provisions because they wanted to allow FHA financing. We've had other clients that have declined to put it in. And we also have clients who didn't care about FHA financing for their owners or for prospective buyers. And so they have kept the seasoning provision. But it is really dependent on your declaration or CC&Rs.
All right. We've covered being a named insured by a contractor, that it helps protect HOAs against personal injury claims. Does it allow an HOA to file a claim directly with a contractor's insurer in the event of damage, or allow any other direct action with their insurer? I don't know what that might be.
So the being named as an additional insured does allow the association to file a claim under the policy of insurance because they are a named insured and they have a contractual relationship now with the insurance company. So if there was a personal injury claim, they could certainly file a claim with the insurance company. I'll say the challenge for this question is that when you talk about damage, it has to be damage which is actually insured under the policy. And usually when I get this kind of question, the association wants to file an insurance claim for faulty workmanship performed by the contractor. And the general liability insurance policy does not provide coverage for faulty workmanship in almost all cases. It is one of the most common exclusions written into contractors' policies and homeowner association policies. And so the general liability insurance, which you are getting, you are being provided coverage under as an additional insured, is for injuries or damage caused by the contractor. It is not a warranty that the work is being done correctly. To be able to answer the question further would require us having a lot more factual information about what the claim is, whether the damaged cause was related to the work being performed. You know, if the contractor brings out of a piece of equipment and the equipment runs into the building and damages it, then that's something that might be covered. But if it's just the contractor doesn't perform the work of the contract, that's not going to be covered by a general liability policy. Anything you want to add, Lisa?
Nope. Anything else, Chelsea?
Yes, snow removal. Some owners have suggested the HOA can be held liable for damages if people or property are injured / damaged because the HOA did not remove snow. Our governing documents do not require the HOA to remove snow. Do we need to be concerned?
Well, snow is a difficult thing because everyone wants to blame you if you don't remove it, or blame you if there's an injury, but they don't want to pay for removal of it either. We actually do recommend that associations have a snow policy. Now, the policy doesn't mean you're going to plow anything or remove the snow. It may just state clearly to owners that if it snows or there's icy conditions out there, that you're on your own and you need to take precautions to protect yourself. There are some cities which have municipal codes requiring that owners remove ice and snow from the sidewalks in front of their homes. I have no idea how these are enforceable when you cannot be out there with a shovel 24 hours a day removing ice and snow from sidewalks. And I haven't seen, in part because I haven't researched much case law on when an owner can be held liable for the ice being on a sidewalk. I can tell you it's certainly likely that if a person slips in snow or ice, they're going to look for someone to blame. And sure, the association is a likely party to get sued. And that's why you buy general liability insurance. It is one of those things which you are buying insurance to manage the risk instead of trying to be out there 24/7 with a shovel removing snow. Your governing documents may or may not have a provision which discusses the obligation to remove snow. I think I've got a couple of communities where it actually is explicit that the association is responsible for snow removal. But then again, I would want you to have a policy that says, well, okay, how much snow is going to require removal? Do you go out when there's only 2 inches? Do you have to remove it if you know it's going to rain tomorrow and melt all the snow? I'm reminded of decades ago working at United Parcel Service and being responsible for snow removal on all of the parking lots and talking with my contemporary over in Spokane. And, in Seattle, 2 inches of snow was a panic. And in Spokane, 2 inches of snow didn't warrant even a comment. And so for us to want to do snow removal might mean, a fairly significant expense when it was insignificant to the guy in Spokane. So it does depend on your community. It may depend on the kinds of risks you have. So snow removal from steps and the sidewalks around the mailboxes might be a different decision than trying to remove snow from every sidewalk in a community. So it is worth trying to evaluate the risk, and we would recommend that you advise owners, even if the advice to the owners is, we're not going to do anything about snow. It's an act of God. A single family home community doesn't do anything about snow, so we're not going to either. But I do appreciate boards making decisions and informing owners in advance of what they're going to do. Anything you want to add, Lisa?
Nope, that's good. Any last questions, Chelsea?
All right, so on the CTA, we've been having the board members sign up individually. We have not filled out the form for the association as an entity, but rather had the board members sign up individually. Based on what I heard you say, do we need to get a separate FinCEN for the association?
It's not a separate FinCEN for the association. It is a separate filing with the Department of Treasury to give the FinCEN numbers from all of the individual board members. It is to identify the association as a corporate entity and then provide the information about the board members. Instead of providing personal information about the board members, you just provide the FinCEN number.
Right, I was going to say that the reporting of the association is what is required by the CTA. You either provide it with personal information of every board member, or the board members go out and get their FinCEN numbers, give that, and you report it with the FinCEN information. So it's a 2-step process either way. You have to gather the information from the board members, whatever that may be, and then file the report. But the board itself is not an entity requiring a FinCEN number.
You give your tax ID number, your EIN, the employer identification number from the IRS when you file for the association with the Department of Treasury.
All right. So next one, our CC&Rs don't have paragraph headings, the few underlined or bold words at the beginning of each covenant. They also have a very lean index. Headings and expanded index would make the CC&Rs more user-friendly. Can the HOA add headings and index topics without a vote of the membership?
Well, you can certainly make yourselves a table of contents, which is not recorded with the county, to make it easier to reference. If you wanted to record a new document with the county, I would probably go ahead and get the approval of the membership because you're changing the recorded document. If you are truly just copying the document word for word, I would think it'd be relatively easy to get the approval from your members. Anything you want to add, Lisa?
No, but if you're going to go ahead and do that, there are changes that need to be made. It might be the time to do it, but that's right. If it's just as simple as just changing the headings, that makes sense. Be easy to get sign on, hopefully.
Do you think we have time for one more?
Sure.
Follow up on compensating board members. What about compensating other owners who do work? What are the pitfalls?
So the one pitfall is, as Lisa mentioned, you risk creating an employee-employer relationship. And so if you're going to do it, we would recommend strongly that you make sure you have an agreement in place that they're an independent contractor and that you're going to report their earnings on a 1099 to the IRS. Otherwise, you're required to do a W-2. We would like to make sure that you have a clear understanding of the scope of work which the person is going to do and how much they are going to be paid. That's true of any kind of contractual relationship. If they're doing something like landscaping work, we'd want to make sure that you have some idea of what they're going to do. In other words, we want a common understanding between the person and the association on what's going to be done and how much it's going to cost. If they're performing other duties like bookkeeping or project management, same kind of thing, we'd want to make sure it's clear what they're doing. We would also normally like to make sure that your community is aware that this work is being done by a fellow owner instead of it being a surprise. So just as Lisa had mentioned, it should be in the budget when it goes out to the owners, and it should be conspicuous that the work is being done by owners instead of by outside professionals. Anything you want to add on that, Lisa?
No, I think we're just about out of time. So if we didn't get to your question today, Chelsea will add them to next week's list. But if you have other questions, email them to info@condolaw.net so we can get them answered for you next week. I think that about wraps us up.
All right. Thanks, everyone.
Thank you.